J.C. Dunn, or Jace Dunn, sorry. And Mr. Dunn was previously in court, entered a plea of guilty to solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, you're.
All right, then at this time, Mr. Dunn, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You will never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
I am handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You also just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. That's for him.
Oh.
Yes, sir.
There you go.
Good morning, sir. You're Ronnie Oliphant. And this is 25 DCCR 0379. Mr. Oliphant was previously in court, entered plea of guilty to the third-degree felony offense of injury to a child. I've received that pre-sentence report, and has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
Judge, just based off the statements and some discussions with Mr. Oliphant, we would ask to withdraw his plea. I understand it's up to your discretion.
So, Mr. Oliphant, obviously, I have some notations here. I know exactly what your attorney, Mr. Comerford's talking about. You denied the offense that you committed the offense in this pre-sentence report. But here's the thing. If I allow you to withdraw your plea today, which I don't have to do because you pled guilty after having sworn under oath that you were going to tell the truth the other day when you were here for your plea. If I allow you to withdraw your plea today, there will be no plea bargains whatsoever accepted. If you want to go to a jury and let them decide, then that's your right. If you didn't do it, then it's going to be up to a jury. We're not going to get down the road a few months and a jury's here waiting outside, and all of a sudden you're like, I really did do it. I'll take that probation or whatever it is. If we do this today, I am making a notation. Mr. Coleman, I'm sure will notate it on his file. Mr. Comerford understands and has been here enough to know that when I say it this way, I mean it. So do you want to withdraw your plea and go to trial?
Yes, ma'am.
All right, then we'll do that and we'll set it on the next available trial docket. Mr. Comerford will.
Just docket wise, the next 2 weeks, I've got a suppression hearing one day, following week.
Oh, no. The trial docket will be, you're probably about 3 months out for the
Okay.
next trial
3
docket.
months. Okay.
Make sure if you have it, that kind of gets us close to in the middle of summer and stuff. So if
Sure.
you have any vacation, make sure you get that vacation letter in.
Yes, ma'am.
Look at that. I say we, Ms.
Okay.
Holmes will look at that before that's it. So if there's any vacation, otherwise it'll get set on the next one, which is about 3 months out.
Okay.
Okay.
Thank you.
All right. Stay in touch with your attorney. He'll let you know when you need to be back.
Yes, ma'am.
And this is 25 DCCR 0260. Mr. Wilkinson is charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, can we call a name this morning?
Yeah, sure.
Samantha Grant.
Can we get, oh, I think she has something going on back there.
Just kidding.
Let me get her back. Say it again, Samantha. Grant.
Samantha Grant. Yes, Your Honor. That's
Would you call the name Samantha Grant, please? Samantha Grant.
No response, Your Honor?
Your Honor, this case is about 1.5 years old, and during that time, I've had no responses to written or telephone communication sent to the complainant without any reason to believe she's pursuing the prosecution of this case, state's going to dismiss.
All right, I'll sign that dismissal this morning. Mr. Boyd, that means your case is over. Obviously, if any, I'm sorry, not Mr. Boyd. Where am I? Mr. Wilkinson. Whatever went on, if anything, between you and Miss Grant, I don't know if y'all are still together or what's going on, but obviously you need to make sure and avoid any type of contact, probable with her or anything like that. You understand?
Of course.
All right, you're free to go, sir.
Thank you.
Mr. Jeffries, you have David Boyd. David Boyd?
Yes, ma'am.
And Mr. Boyd's case is set for trial to begin with jury selection next Monday afternoon, charged with deadly conduct, discharging a firearm in cause number 25 DCCR 0720. And what is the announcement?
We're ready with the exception of I am also on a trial docket in Polk County with an individual who's in custody. And he's at the top of the list over there. So
Okay. I'll take that. Is the state ready?
Stays ready, Judge.
I'll take that into consideration. We do have a couple of much older cases here also, and so if for some reason it starts looking tomorrow, like you may end up closer, then we'll discuss that a little further.
yes,
Mr. Boyd, stay in touch with Mr. Jeffries. He'll let you know, if your case is going to be numbered for trial and what number it is and when you need to be back next week. Okay.
yes, ma'am.
All right. You're free to go. Thank you.
Thank you, Your Honor.
Gomez. This is cause number 21-37252. Mr. Gomez is on probation for driving while intoxicated, third or more. I received a memorandum from probation asking for a judicial review. Let's see, remind myself. Looks like you've went through the safety program and had the SCRAM and an ignition interlock device. The SCRAM was removed after safety. And you were ordered to JCDI for aftercare. Oh, I know. Well, after continuously testing positive for illegal substances on your drug patch, you received sanctions, testing positive for alcohol, and testing positive on your drug patch. You've now been in the program 9 months, but your most recent drug patch again tested positive for methamphetamine. Turned in a hair follicle. Okay. Have a seat in the jury box. Let's get a test done this morning and then we'll talk about it a little bit more.
Absolutely.
Okay.
Nursing? Are you nursing?
She was a small child. I was inquiring, she was nursing this as a small child. Infant with her.
All right, are you LaAsia Clemens? And Ms. Clemens, in clause number 25 DCCR 1339, you're charged with the second-degree felony offense of robbery from September 9th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation and a $1,000 fine. You've got every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? Yes or no? And is there any reason, I mean, obviously that offer is with a deferred probation, any reason to believe that that would change?
To my knowledge, Judge, Mr. Kimler has yet to review the video. So.
I understand the facts from her on what happened. She was charged as a party to the offense. There was a chemical agent deployed by the co-actor in the course of attempted theft.
Okay.
She was no part of it.
So I want to make sure you understand, Miss Clemens, that after today, I will not accept this plea agreement. So if you want to go to trial, then that's what we'll do. We're not going to say later, oh, there's something that Mr. Kimler has or hasn't seen, and that's going to change. If I put it on the trial docket, it'll be a trial, or if you change your mind and want to enter a plea of guilty, it would either be open to the court or just something different and not as good as this 5-year deferred probation. Do you understand? All right, then we'll set it on the trial docket. Mr. Kimler will begin preparation for trial.
Your Honor, did I hear the court correctly that the court would not give her, it would be worse than 5 years in an open plea? Worse than
No,
5
that
years?
she would not be, this 5-year deferred probation would not be on the table at that time.
I thought I maybe misheard that the court said it would be worse than 5 years if she didn't accept it.
Not worse than 5 years in prison,
Oh, 5, I meant more than
but she's
5
not,
years.
this deal will not be on the table. So if you change your mind later, it'll be either open to the court or to something different, but not this deal. And if it's not this deal, it's also not going to be less than this deal. So I'm not going to accept y'all coming in here a day of trial and say, well, we'll take a 3-year deferred instead of a 5-year deferred.
Okay,
Does that make sense?
that's what I think it should be from whatever the punishment range is, Your Honor, what's available to the court, and it not be a prejudice by our
That's
factors.
that's not what I'm going to do. That's
Okay.
if y'all make a negotiation and want to come in and plea. If you plea open to me, it's anywhere in the punishment range.
Which
If y'all change your mind, then, and you want to enter some negotiated deal, I'm not going to accept this again.
Oh, I see. But the court still in an open plea could go less than 5 deferred, would consider something less than.
I'll
5 years.
consider the entire punishment range as I'm legally obligated to do. All right, stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back and ready for trial. Ready to go.
Yes,
And in cause number 24, DCCR 2168, Mr. Polanco is charged with aggravated robbery. I know we'd been waiting on a case.
It was brought over last week, but it was after review. It was too late to get it on for the grand jury. So
Okay.
one more, we said we should have it indicted, Judge.
Okay,
And then
perfect.
He's gonna need to post a bond.
So I'll just do a normal reset. Mr. Polanco, stay in touch with Mr. Kimler. Obviously, when that case gets indicted, I don't know if you've already made bond on it when you were arrested or not. If not, there will be a warrant. You'll need to turn yourself in, bond on that one if you can, and then we'll see where we are the next court date. All right, you're free to go, sir.
Stay in touch with Thomas.
And then you've got Jose Lopez. Are you Jose Torres Lopez? And Mr. Torres Lopez is charged with solicitation of prostitution, set for trial to begin with jury selection next week. What is the announcement?
Great.
State is ready, Your Honor.
So, Mr. Kimler, if a client needs an interpreter, if you need an interpreter for him, you're hired. Typically, that would be something that you or he would provide. If not, he needs to file an affidavit quickly of indigence in order to, or a motion.
I'll have an interpreter. I have my own. That's fine.
Okay. I mean, and if he can't afford it, then file a motion with that affidavit attached to it. But we need to know that once I number the case.
I think I could file that in good faith, Your Honor. So, well, I'll have you.
Okay, then I will number the case tomorrow after the docket. Mr. Torres Lopez, stay in touch with Mr. Kimler. He will let you know tomorrow the trial order and what time you need to be back and when on next Monday.
Talk to Marie. We'll call. Friday.
Junior, and this is 24 DCCR 2353. Mr. Gage is charged with evading arrest or detention with previous convictions. And what is the announcement?
Your Honor, if we could just have 30 more days for an announcement. We've gotten an offer, we've gotten written discovery, but we want to get the video discovery.
Okay, and it looks like you were just hired in January. Is that correct? Okay, any issues? All right, I'll just do a normal reset. Mr. Dage, make sure you stay in touch with Mr. Lane so that when he gets all of that information, including any video, you can go visit with him, watch that, and then we'll get an announcement at the next court date. All right, you're free to go. And you, Ahmad LeBlanc.
Yes, Your Honor.
Mr. LeBlanc, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand on. And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LeBlanc, in cause number 21-36444, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 19th of 2021 for aggravated assault, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
It alleges that you violated your probation. Count 1 alleges that you committed a new offense of possession of a controlled substance, penalty group 2, September 1st of 2025 in Chambers County, Texas. And is that true or not true? Count 2 alleges that you provided a urine sample August 3rd of 2022 that tested positive for marijuana. Is that true or not true? And then count 3 alleges that you're behind in your court assessed fees as of December 10th of 2025 in the amount of $480. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
Did you plead true to those counts because they're all actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for sentencing so that we can get an updated pre-sentence report. And then we'll go forward with sentencing. Before I let you go today, however, I'm going to get a drug test here in court. I want you to have a seat in the jury box. All right, so on Mr. LeBlanc's case, which is 21-36444, we went through the motion already, which is a motion to revoke unadjudicated probation, where Mr. LeBlanc is on probation for the second-degree felony offense of aggravated assault. He pled not true to counts 1, 2, no, pled true to counts 1, 2, and 3. I got a drug test done. Mr. LeBlanc tested positive for THC. And so obviously, when's the last time you smoked marijuana?
The day I had to turn myself in, but the probation.
What made you think that would be a great idea? So he pled true to a possession of a controlled substance, a new offense, tested positive. So at this time, Mr. LeBlanc, you're on probation already. I granted you a bond because of that deferred probation status, but the fact that you're on probation and on bond and testing positive for THC, there's clearly an issue. At this time, I'm going to find that it is in the best interest of you and the community that there is not going to be a bond. I'm going to withdraw your bond at this time and find those violations. And then what I'm going to do is have probation do an updated report. You've pled true that you're obviously there's an issue. There's a new felony offense. And so we'll get an updated report and then we'll see what we're going to do at your probation sentencing. Okay, you can go back with the bailiff.